Hi, and welcome back. This is Jenna Scott, and I am reading Carlton Weiss's Concise Trustee Handbook, circa 2008, and we are on the section titled Issuing Certificates and Bonds. As discussed in this earlier section, the trustees may issue certificates of beneficial or capital interest or other obligations to any person they choose. Footnote 157. There are a total of 100 units of beneficial interest and a separate 100 units of capital interest in the trust. The trustees determine the number of units, percentage of total interest, to be held by any one interest holder, and may issue the full 100 units, 100% of either interest, to a single individual. To issue a certificate of either interest, the trustees must act jointly as the Board of Trustees unless there is only one trustee for the trust. They should execute under seal, footnote 158, then deliver to the interest holders the actual certificates evidencing the interest held. The board should also record minutes of the meetings in which it was resolved to issue the interest, and then record the act along with the interest holder's identification information in the appropriate schedule. With certificates of capital interest, the method is much different, though the procedure is the same as that for the trust certificates. Capital certificates work based upon barter exchange with investors called exchangers, who may be anyone the Board of Trustees wishes to barter with. The Board of Trustees determines the number of units to issue in exchange for the property proposed for investment into the trust. This is a pure barter between the parties, and whatever number of units is agreed stands as the full value in exchange for the proposed property. Footnote 159. The exchanger should present a written proposal, an example of which is provided in the sample form section, to the Board of Trustees. Any negotiations which take place should be recorded in the minutes in which it is resolved to either issue the interest or refuse the proposal. If the Board of Trustees has resolved to issue the interest and make the exchange, their certificates must be executed and delivered to the interest holders, and the properties in exchange must be delivered by the interest holders to the Board of Trustees. The final act should be recorded along with the interest holders' information and the property inventoried in their respective schedules. With bonds, because a bond is merely an obligation or promise to pay money or to do some act upon the occurrence of certain circumstances, the trust need only issue the bond according to the particular transaction, e.g., to back the performance of a particular contract, to raise capital from outside investors in the form of IOUs, etc. The distinguishing feature of a bond is that the document shows an obligation to pay some fixed amount of money or services at a definite time with stated interest. I have provided some samples for various uses in the sample form section. Now, there is no rule against a trustee or agent of the trust exchanging his individual property for capital interest in the trust, and there is no rule against the trustee or agent holding beneficial interest either, though the holding of beneficial interest is generally regarded with greater suspicion than capital interest. The actual rule is that either transaction will be sustained as non-voidable if it clearly appears free of fraud, concealment, or undue advantage. Footnote 160. This means any omission by the trustee or agent to disclose any material fact of the deal, which is learned by the trustee by virtue of his office, and any misrepresentation, concealment, or other disregard of condition renders the issuance, exchange, and contract voidable at the option of the beneficial interest holders. And one can wager that any accusation of invalidity of the trust by an outside party will be made on those grounds as well. The suspicion, however unreasonable without regard to the particular merits of the situation, stems from the many express trusts successfully dismantled based upon the unscrupulous and often foolish failing of the control test. In fact, the express trust graveyard is mostly populated with the dead corpuses of trusts who died from this very mistake. When a trustee holds all or a majority of interest, beneficial or capital, in the trust, he is, in effect, an interest holder exercising control over the affairs and res of the trust. He derives the sole benefit of his actions and determines the actions which would cause him to derive the sole benefit. He is owner of the legal title to the trust property as trustee, as well as owner of the equitable title to the property as interest holder. At best, the trust is his alter ego. Hence, he must be proceeded against as though the trust does not even exist. This is why it is recommended that any transfers between trustee or agent and the trust or interest holder be by sale as prescribed according to the guidelines, though a third party, or by outright exchange, with all documents in support of the transaction ready to repel the outside party who might attempt to come in under the guise of the express trust's grim reaper. And that brings to an end the section on issuing certificates and bonds. And I will see you back for the next section, which is going to be keeping minutes. And I will see you there.